help. There's
I'm
something
sorry?
wrong with you. You have
You
a
said
mental
what?
You have a mental problem.
I have a mental problem. How?
The United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world. There's clearly something wrong with you.
No, what did I make up?
The video opens with Judge Washington setting the tone for what's clearly going to be a chaotic hearing. From the start, she wastes no time addressing the defendant, a self-proclaimed sovereign citizen, with a sharp and no-nonsense attitude. Her frustration is visible when she calls out the woman's bizarre belief that laws don't apply to her. The judge's calm but firm demeanor contrasts sharply with the defendant's combative energy. This opening perfectly captures how judges often have to deal with people who think internet theories can override real law. The tension is immediate, and viewers can tell this isn't going to be a normal eviction case. It's about to be a full-blown legal meltdown. And Judge Washington isn't here for nonsense.
Antira, if you, the court will call the case of the Ranches of Rosebrook versus Anise Battle, case number 25C-1245.
Good morning, Your Honor. David Fanter on behalf of the plaintiff.
Battle, please unmute and state your name.
Anise Battle, appearance especially, not generally.
Thank you. All right, we're here for the continuation of the hearing today. Battle, when you're not speaking.
You said, can I mute my mic when I'm not speaking?
Correct. Thank you. All right, Mr. Fantira, I believe that we are in the middle of your, well, actually it was Ms. Battles. Direct.
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
That's correct. Ms. Battle, are you ready to proceed?
Yes. So, Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to the terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Ms. Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
Your Honor, I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong, and one of the things you stated was the Magna Carta, which was from the 12th century in England.
No, I stated it under common law
Please
and
stop.
landlord-tenant acts.
That's not, we're not under common law anymore, ma'am, and that's a part of the problem with sovereign citizens. They think they know the law when they don't. That is.
As the hearing proceeds, we learn that the case is between the property managers, the Ranches of Rosebrook, and a tenant named Anise Battle. When the judge asks her to unmute and state her name, Battle replies with appearance, especially not generally, which already signals that we're dealing with someone using pseudo-legal gibberish. The plaintiff's lawyer appears calm but likely realizes he's in for a long morning. From the way the judge handles battle, it's clear this isn't their first encounter, and everyone, including viewers, can feel the coming storm. This early exchange sets the scene for an absurd tug-of-war between real law and fantasy law. Next,
As your basis is still not correct. It is not the law.
It is. It's still under MCL and it's under the Landlord-Tenant Act.
Overruled.
My objection is overruled, Your Honor?
No, the objection is sustained. Her question, it cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was
Because
rescinded?
that's not the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated,
My ruling, I'm not arguing with you anymore about it.
right, it's not an argument, so just let the record show that there is no law or basis to what she's saying, and she has not yet stated any law or fact behind this objection to
Ma'am,
asking these
please
questions.
move
I will
on.
continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A
Dawn.
demand for possession, yes.
No, a notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Ms. Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Ms. Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You studied a statute that I actually need to look up. MCL what?
I'm sorry?
What was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600 point.
begins her questioning by asking the landlord's representative if she ever waived her rights in writing. The courtroom pauses, unsure what she even means. The lawyer tries to stay polite, explaining there's a signed lease, plain and simple. Battle, however, continues to argue that signing a lease somehow doesn't mean she agreed to anything. This part highlights a common sovereign citizen tactic: use random legal terms to confuse and stall proceedings. The judge quickly loses patience, knowing this circular logic will go nowhere. The absurdity is comedic, but in real life, it's a serious example of how misinformation spreads legal chaos.
Yes, I had read it when I first did this.
It uses the term demand for possession.
Okay, everybody please stop talking. It says, a demand for possession or payment shall be in writing, addressed to the person in possession, and shall give the address or other brief description of the premises. It's a demand for possession, not a notice to quit.
Okay, so is there proof of service of it on the record?
That's a different question though. So, okay, go ahead.
But that's the question I asked next. Once he said that the
But I
demand for
wanted to
possession.
clarify your question before.
I appreciate it.
All right, Ms. Charles, please add, her question next is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's not using the statute changed 10 years ago so that you now need, on a demand for possession, a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Plaintiff's lawyer tries to move things along. Battle insists she rescinded her lease, meaning she believes she unilaterally canceled the contract by declaring it void. The judge and attorney both try explaining that rescission doesn't work that way in contract law. The lawyer clarifies that this case is about unpaid rent, not rescission, but Battle won't let go. Her misunderstanding of common law and Magna Carta only makes it worse. Judge Washington's patience finally snaps as she bluntly tells Battle that we're not under common law anymore. It's both hilarious and painful to watch. Someone argued 12th century English law in a modern Michigan court.
So let's not make my ruling.
Let's just okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service
Okay,
is
answer that question.
not on the disposition. And just like she read on 657-16, was the property described on that disposition?
Yes.
Was there a description of the property?
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no such grievance procedures under this anything that I'm aware of. I mean, I don't even know what she has a grievance about.
Right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not.
No, we're not publicly.
Well, you accept HUD housing. You accept HUD housing, and you apply, and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
object to what? I didn't say anything yet.
Well, I'm objecting because she asked Miss Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume anything. I asked the question.
Okay, what was the question you were going to ask?
I said, do you have to follow HUD's policies? That was my next question.
And she said yes.
Right. And then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth before you objected me.
Let her ask the next question, and if you have an objection, I can hear it after she finishes her question.
Okay.
Okay. Are you aware that before you initiate a hearing in court or the administrative process before court, you have to have an administrative hearing by a HUD administrative judge?
Your Honor, I object. I'm not aware of any.
Say no. I mean, that's
Just
not.
say no because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No, it doesn't, because that is not the law, ma'am.
How is it? Okay.
You're making.
Are you aware of the requirement under 42 USC 1437 DK for federally funding or accepted landlords to resolve disputes through HUD before an eviction proceeding?
Your Honor, again, I'm going to object. The fact that Ms. Charles answered the question about having a relationship with HUD doesn't mean we are a federally funded property.
I didn't say that you were federally funded, so let's be clear.
Washington points out that Battle's arguments sound exactly like those used by sovereign citizens, the anti-government group famous for quoting irrelevant laws. Immediately, Battle gets defensive, denying she's one of them. The judge delivers one of the best lines of the video. "If it walks like a duck and talks like a duck." Her sarcasm lands perfectly. It's a moment where the courtroom tension breaks with humor, but it also underscores how frustrating these hearings can be. Sovereign citizens often claim not to be part of the movement while repeating its exact nonsense. Judge Washington's quip becomes the episode's most memorable punchline.
It is correct, because if you received any type of funds from HUD, which is through Section 8 vouchers or regular vouchers, you get what I'm saying? You receive funding from HUD.
We are, do you?
I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. Ms. Battle does not receive a voucher, and so all of this questioning.
Well, it doesn't matter if I receive a voucher. It matters that you are of that type of entity that needs to go through HUD because you accept those things. So
Your
you
Honor,
agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that how am I making it up? It's under 42 USC 1437 DK.
Battle.
It's a federal registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through that process to collect rent, ma'am. That is not how it works.
Okay. Okay. You're saying that it doesn't have to, but HUD says that these are the requirements. Hence why MCL at the bottom is trying to align with HUD guidelines on the same registrar that I'm talking about. You have those codes at the bottom that match up with HUD.
Move on.
Okay. So, well, obviously, if I can't really get a line of questioning, I'm being objected because he feels it's not right. He is objecting with no laws or facts behind anything he's saying. He's just thinking it off the top of his head.
The narrator steps in to explain that Battle's claim actually resembles something legitimate: constructive eviction. That's when a tenant can leave a rental if it becomes unlivable. But since Battle kept living there, she legally gave up that argument. The commentary perfectly exposes how these sovereign-style litigants misuse real legal terms without understanding them. The narrator calls her a ducking fool, emphasizing the comedy of watching someone self-destruct legally while thinking they're outsmarting the court. This section balances humor with education, breaking down the actual law while keeping viewers entertained.
My plaintiff.
Your Honor, I object. The court's already said they have jurisdiction over the
The
property.
court said that she had jurisdiction because she said so, and that's non-judicial.
Okay. Ms. Battle, move on.
Move on to what? If
Not-
I cannot have, this is not a fair hearing, and again, this is why
not, you're trying to turn this into
I'm not trying to turn it into anything. I'm just trying to state the
Please.
laws, and I'm not trying to argue with y'all about anything. You get what I'm saying? I'm not trying to argue with y'all. I'm just trying to get y'all to state and prove y'all facts, and y'all have not proven any facts, but for some reason are hindering me in this proceeding, and that's why I took this case to the U.S. District Court in Eastern. That's why there's an open case right now with all of you all, because this is just not. And I told the Attorney General, and I told the IRS, and I did everything else because at the end of the day,
Please move
all of
on.
this is not right.
I'm telling you
And
now
attorney
that I'm going to be filing criminal proceedings against you for all these frivolous things.
Battle then changes tactics, asking the landlord if they ever sent her a notice to quit. The lawyer objects, explaining that in Michigan, evictions start with a demand for possession, not a notice to quit. The judge patiently clarifies the difference, but Battle refuses to accept it. It's like watching someone lose a game they don't understand yet insist they're winning. The audience learns how technical eviction law really is, while also seeing how quickly a case can derail when one party has no legal grounding. Judge Washington's restraint here deserves applause. Many judges would have ended the hearing already.
My rights are not frivolous.
Please move on.
It's honestly, if I can't have a fair hearing, nobody has any facts. Y'all talked about constructive possession. Nobody wants to talk about that. Y'all keep saying that I rescinded a contract unilaterally. That's not the case. It's called notice. And when it goes a notice goes unrebutted, just like if I was to come here, if I was to get that notice of dispossession and get a notice of a hearing, and I missed that hearing because I did not rebut, that would constitute as
cross-examination.
Battle, if
That
you're
would
not
constitute
going to
as the
ask
same
appropriate
type of
questions, then I'm
law.
just going to silence you. So you get the opportunity to ask your questions, or you can just be silenced.
I don't have a real opportunity to ask the questions. So at this point, like I said, I'm just gonna have to get the federal court involved and get the marshals.
When Battle proudly cites Michigan law, she completely misreads it. The judge double-checks the statute herself and gently points out that Battle quoted it wrong. The narrator humorously highlights that Battle can't read neither, adding a layer of dry humor to her confusion. This section perfectly captures the absurdity of sovereign citizens who Google random statutes but never understand what they mean. Judge Washington even asks everyone to stop texting her mid-hearing, another real-world reminder that these Zoom court sessions are chaos. Despite all the madness, the judge stays composed, giving viewers a masterclass in judicial patience.
So I don't know. I'm stuck on what to do. The integrity of the court is questioned.
With you. I don't know what that is, but you should seek some mental health. Because something's wrong with you. You have a mental problem. You have a mental problem.
I have a mental problem. How?
The United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world. There's clearly something wrong with you.
No, what did I make up?
All of it.
What? Be specific. Right. No, be specific, because now you're lying on the record. This is perjury. I didn't make nothing up. 42 USC definitely applies to this case.
All right.
Jurisdiction is a threshold.
Ma'am, if you don't stop, I'm going to remove you from the court proceeding. So, Mr. Fantera, apparently we're not going to have a reasonable hearing here today because Ms. Battle feels as though the laws are very different for her as opposed to everybody else in the world. I'm not certain how to handle this going forward. You have submitted your documentation and she wants to argue stuff that's not law, regardless of my rulings. So therefore, I'm not sure what to do with respect to your case.
I would ask for a directed verdict. She hasn't said anything that is a defense to my action, and I submitted a proposed judgment this morning. There's rent owing in the amount of $3,432.42, court costs of $177 for a total of $3609.42. We would ask for a judgment for possession with a writ after 10 days, and she can avail herself of whatever procedures she can in another court.
So you're saying that none of my objections.
Expressing about proof of service, confusing it with certificate of service. The attorney, visibly tired, explains that the law changed years ago. It's no longer called proof of service. Battle argues anyway, unaware she's proving the lawyer right. The narrator adds a funny reminder about her earlier contradiction, replaying her own words to show how she forgot what she said less than 2 minutes earlier. It's the perfect comedic edit, one that exposes her delusion while keeping the tone light. This part really shows how logic collapses when someone argues from misinformation instead of facts.